Even if you create an estate plan, there is always a chance that someone will contest it. Will contests are more common than most people realize. When one person believes they're entitled to a share in an estate or disagrees with how the estate is being distributed, they can contest the will. I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law. And in this video, I'm going to explain what happens when a will is contested. In California, only interested parties can contest a will. Interested parties are people who have benefited under an earlier version of the will or heirs of the decedent not included in the current will. The person contesting the will has a right to file an objection with the court to stop the court from probating the will. After an interested party files a petition to stop the probate process, the executor of the estate needs to inform the following people that there has been a will contest: the known heirs of the deceased person, each person named in the will, if one exists, any alternate executors. These individuals have 30 days to respond to the will contest. Next, there will be a hearing in front of a judge regarding the will contest. The person contesting the will must provide the court with evidence, provided the grounds on which the will contest is based. For example, suppose a daughter claims that her brother used undue influence over her father to cut her out of the will. In that case, the daughter would need to provide the court with evidence of the undue influence exerted over her father. If the people benefiting from the will that is being challenged receive notice of the will contest and then do not respond within that 30 days, the case might go ahead without them. In this scenario, the person contesting the will would be able to submit evidence. Since nobody would be present to challenge the evidence at the hearing, the judge may rule in the petitioner's favor. The parties who did not respond would be bound by the court's ruling in this case. If you receive notice that a will contest is occurring and you are one of the estate beneficiaries, it is crucial that you discuss your case with a lawyer as soon as possible. At the end of the hearing over the will contest, the probate court judge may choose to accept the will entirely or reject part of the contested will. In some cases, the judge will reject the will entirely. If the person contesting the will claims another will that supersedes the contested will, the judge may decide to enforce the current will. When there's only one will and the judge determines it to be invalid, the probate court will distribute the decedent's property according to California intestacy laws. In California, there are several different legal grounds for contesting the validity of a will. Namely, the testator who created the will did not have testamentary capacity. Another person had undue influence over the testator in preparing or executing the will. The will was not signed and executed properly. Another person unduly influenced the testator in creating the will or including certain provisions that benefited them. Mistake, revocation, duress, fraud, each of these legal grounds can be difficult to prove. The person contesting the will needs to obtain medical records, witness testimony, and witnesses' declarations. Additionally, they may need to hire experts to provide their expert opinions. Contesting a will is not easy and can become an expensive court process. According to California law, a beneficiary or potential beneficiary can contest a will in California if the will was not created and executed properly. California requires specific testamentary formalities for a will to be valid. Specifically, California wills must be in writing and signed by the testator who created the will, or by another person in the testator's presence and by their direction, or by a conservator according to a court order to make a will according to the California Probate Code. Additionally, the will must be witnessed and signed by the testator during their lifetime. 2 additional people must witness the testator signing the will and sign the will themselves if the will is not in the testator's own handwriting. The witnesses must be present and witness the testator signing the will or the testator's acknowledgement of the signature of the will. Remember that spouses who create a will in California may only devise their interest in the community property. Most property either spouse acquires after the marriage will be considered community property, and the surviving spouse will have a right to 50% of it. If a spouse tries to disinherit the other spouse in a community property state, the spouse is still entitled to 50% of the property. The surviving spouse has a right to contest a will that does not leave them 50% of the community property. If you have any questions about will contests or any other type of estate litigation, please contact our office for a no-cost consultation with one of our attorneys. Thanks. We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.